Greetings to you once again, and welcome to Know Your Rights University in association with Natural Essence LLC. We are back at you once again, hoping to share information that is educational and of benefit to you and your family. Let us begin by sharing our screen. The title of this video today will be, What is Generational Wealth? Let us share our screen. What is generational wealth? Generational wealth refers to the transfer of tangible and intangible assets such as land, homes, businesses, cultural knowledge, and community-based governance systems from one generation to another. This concept is not merely economic in the constitutional and legal framework of American self-governance. It is deeply tied to property rights, inheritance law, tribal sovereignty, and the broader constitutional protections of unalienable rights, including local and tribal self-governance. Legal and constitutional dimensions of generational wealth. Constitutional right to property and self-governance, the foundational documents of the United States, particularly the Declaration of Independence and the Constitution, support the inalienable right to property. This right is a cornerstone of generational wealth because it protects the individual's ability to own, develop, and bequeath land or resources, particularly without arbitrary interference by the state. Assembly Clause and the right to self-govern. According to the constitutional right of self-government, the Assembly Clause was originally understood to protect the ability of communities, especially families, tribes, and townships, to govern themselves and protect their property interests. Thus, generational wealth includes the legal autonomy to manage and pass down resources within such self-governing bodies. Tribal sovereignty and inherited wealth. Tribal governments and indigenous communities, as discussed in the Aboriginal self-government in the United States, face ongoing legal instability due to their dependence on federal policy and judicial interpretation. Although tribal lands and resources are intended to be held collectively and inherited intergenerationally, they remain vulnerable to federal trust doctrines and congressional oversight that inhibit secure passage of wealth across generations. Self-determination as an economic engine. In Native Children Commission hearing testimony by Dr. Joseph Colt, self-governance is shown to be essential for fostering intergenerational prosperity. Tribal nations that assert control over their natural resources, taxation, education, and court systems are far more successful in building sustainable economies. These tools allow for the creation and maintenance of wealth that benefits future generations. Local government and generational wealth in communities. Making the case for the right to local self-government emphasizes that local lawmaking is a crucial expression of sovereignty. When communities are allowed to create and enforce laws that protect land, water, and local economies, they are essentially protecting the infrastructure of generational wealth. The ability to retain resources, values, and autonomy within families and neighborhoods. Conclusion: generational wealth in a constitutional sense, is not merely the accumulation of material assets. It is the protected right to transmit those assets, knowledge systems, and governance capacities from one generation to the next without arbitrary interference by centralized power. It is intimately connected to the right of self-governance under both federal and state constitutions, the right to own and manage property securely, the sovereign autonomy of indigenous nations and local communities, The preservation of the preservation of cultural and legal traditions that secure wealth in all its forms. This understanding affirms that generational wealth is both a legal condition and a constitutional imperative for sustaining the sovereignty of the people. The phrase, although tribal lands and resources are intended to be held collectively and inherited intergenerationally, they remain vulnerable to federal trust doctrines and congressional oversight that inhibit secure passage of wealth across generations means the following in legal constitutional terms. Tribal lands and resources are intended to be held collectively and inherited intergenerationally. This acknowledges that under tribal law, custom, and treaty tradition, the land and resources of native nations are not privately owned by individuals but are held collectively by the tribe for the benefit of current and future generations. This reflects a principle of communal stewardship, a foundational element of tribal self governance and economic continuity. The goal is to preserve the land base and wealth for descendants, not merely for present use. They remain vulnerable to federal trust doctrine. Here, federal trust doctrine refers to the legal principle whereby the U.S. federal government holds title to tribal lands in trust for the benefit of the tribes. While intended to protect tribal property from external seizure, the doctrine gives the federal government legal control over how the land is managed, leased, or transferred. In practice, this limits tribal sovereignty, complicates economic development, such as tribal nations cannot sell or collateralize land without federal approval, and delays or prevents efficient intergenerational transfers of value or usage rights. This trust relationship, as described in Cherokee Nation versus Georgia, creates a ward to guardian model that subordinates tribal authority to federal discretion. Congressional oversight. Congress holds plenary power over Indian affairs, meaning it can pass laws that affect tribes unilaterally. This authority is not constitutionally limited by tribal consent and can redefine or restrict tribal authority over land and resources, alter or terminate trust responsibilities, and impose regulations that limit the autonomy of tribal economic or inheritance systems. This means that even if a tribe adopts policies to preserve wealth for future generations, Congress can legally override those policies, inhibit secure passage of wealth across generations because of the combination of federal control under the trust doctrine and congressional power to interfere, and bureaucratic obstacles such as delays in trust asset management, probate complications, and lease restrictions. Tribes often cannot guarantee that wealth, land, mineral rights, timber, water rights can pass from one generation to the next securely or efficiently. This undermines tribal efforts to build long term intergenerational prosperity. In summary, this phrase critiques the federal legal structure that undermines the constitutional and natural right of tribal nations to exercise full property control, governance, and wealth succession, despite their intentions to preserve and transmit resources communally. It signals that true tribal sovereignty and economic independence remain incomplete, constrained by federal legal mechanisms that erode the stability of generational wealth within indigenous nations. This tribal sovereignty and economic independence remain incomplete due to being under a public trust, if you will. Public trust, meaning that the federal government held legal title to their tribal land for the benefit of the tribe. In our video, The Beginning of Trust, we define what a trust is. What is a trust? A trust is a fiduciary and equitable relationship lawfully formed when one person, the grantor or settlor, conveys title, legal, equitable, or both, to another, the trustee, for the benefit of a third party, the beneficiary, under enforceable terms and conditions defined by the trust instrument, and subject to the fiduciary obligations recognized by law or established by contract. A fiduciary is a person or entity that is entrusted to act for the benefit of another in matters within the scope of their relationship. The fiduciary has a duty to act with utmost good faith, loyalty, and full disclosure toward the principal or beneficiary and must not seek personal gain from their position. In our book, What is a Legal Duty and How Does It Pertain to Individual Rights, we said, to the founding generation, the liberties of speech and press were intimately connected with popular sovereignty and the right of the people to see, examine, and be informed of their government. For example, in one of the most famous 18th century essays on the freedom of speech, Whig commentator Thomas Gordon explained that men ought to speak well of their governors is true, while their governors deserve to be well spoken of. But to do public mischief without hearing of it is only the prerogative and felicity of tyranny. A free people will be shewing that they are so by their freedom of speech. The administration of government is nothing else but the attendance of the trustees of the people upon the interests and affairs of the people, and as it is the part and business of the people, for whose sake alone all public matters are, or ought to be transacted, to see whether they be well or ill transacted. So it is the interest, and ought to be the ambition of all honest magistrates to have their deeds openly examined and publicly scanned. In American jurisprudence on public officer, 63C, am juror, public officer, it states, Section 3, nature as public trust or agency. West Key, number digest, officers and public employees. Number 1 states, every public office is created in the interest and for the benefit of the people and belongs to them. Thus, a public office is a public agency or trust created in the interest and for the benefit of the people. Such trust extends to all matters within the range of the duties pertaining to the office. Section 4, generally, the characteristics or elements of a public office include its creation by law, that is, by statute or constitution. Is there something in the Constitution or a statute that gave the federal government the right to have control over tribal land, such as stated in this phrase, although tribal lands and resources are intended to be held collectively and inherited intergenerationally, they remain vulnerable to federal trust doctrines and congressional oversight that inhibit secure passage of wealth across generations? We ask this question to possibly gain some understanding as to why the need was presumed for the federal government to control the tribal lands of the indigenous people, which in effect inhibited their right of self-governance and their ability to pass on land to their heirs. We asked this question of ChatGPT, and here is the answer that was given. No constitutional provision directly grants the federal government original authority to control tribal lands. Instead, such authority has been assumed through judicial interpretation, statutory enactments, and the doctrine of plenary power, which is not explicitly stated in the Constitution. To answer your question with legal and historical precision, no explicit constitutional grant of tribal land control. The U.S. Constitution contains no clause that authorizes Congress or the executive to hold tribal land in trust, regulate tribal property, or restrict its inheritance. The only direct references to native nations are Article 1, Section 8, Clause 3, Indian Commerce Clause, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Article 1, Section 2, Clause 3 refers to Indians not taxed in relation to apportionment a population classification, not a power grant. These clauses do not grant authority to govern internal tribal matters, do not authorize land title regulation, and do not empower federal trusteeship or plenary control. The federal trust doctrine is judicially created, not constitutionally granted. The trust doctrine, the idea that the U.S. holds tribal lands in trust for the benefit of native peoples, arises from judicial interpretation, not from the Constitution. It was born from the Marshall Trilogy, Johnson versus, I guess it's McIntosh, invented the doctrine of discovery, declaring that only the U.S. government could acquire Indian lands, not private individuals. Cherokee Nation versus Georgia described tribes as domestic dependent nations under federal protection. Worcester versus Georgia affirmed tribal sovereignty but still within a framework of federal supremacy. None of these cases were based on express constitutional text. They were founded on assumptions of federal supremacy and international law concepts applied to Indian lands without tribal consent. Congress asserts power via statute, not constitution. Federal statutes such as the Indian General Allotment Act or the Dawes Act of 1877, the Indian Reorganization Act of 1934, the Indian Self-Determination and Education Assistance Act of 1975, and 25 United States Code sections 461, Title 25, Indians are not rooted in express constitutional authority. They are enacted under the Indian Commerce Clause and the judicially created doctrine of congressional plenary power over Indian affairs. The plenary power, the ability of Congress to legislate freely over tribes, is not enumerated in the Constitution. It was created by courts, especially in the United States versus Kadama. The court admitted that no clause gave Congress direct authority, but justified it as necessary because of the weakness and helplessness of these dependent communities. This reasoning conflicts with 10th Amendment principles and is not based in the text or original intent of the Constitution. Treaties and tribal consent. Many tribal lands were set aside or protected by treaties ratified by the Senate under Article 2, Section 2, Clause 2. However, treaties are contracts between sovereigns, not grants of federal trusteeship. Now that treaties have been unilaterally stopped post 1871, congressional statutes have replaced consensual relations with unilateral control. Tribal land control today. The phrase you reference, they remain vulnerable to federal trust doctrines and congressional oversight describes the contemporary legal reality which lacks express constitutional origin and rests instead on judicial doctrines and legislative policy, not consent of the governed or enumerated powers. Constitutional conflict. This federal control regime conflicts with constitutional principles, including the 10th Amendment, which reserves all powers not delegated to the federal government. The 9th Amendment, preserving unenumerated rights, including tribal sovereignty. The Treaty Clause, which presumes good faith and mutual sovereignty. James Madison, Federalist Number 45. The powers delegated by the proposed Constitution to the federal government are few and defined. The assumption of total control over tribal land is not among those defined powers. Conclusion: no, the Constitution does not grant the federal government control over tribal land. That control was created through judicial intervention, trust doctrine, plenary power, expanded through federal statutes not grounded in tribal consent, and stands in tension with foundational constitutional principles, especially sovereignty, consent of the governed, and limited government. The federal trust system is, in this light, extra-constitutional and arguably colonial in character, not constitutional. What does extra-constitutional mean? Extra-constitutional refers to actions, doctrines, powers, or systems that exist or are exercised outside the express text, structure, or delegated authority of a written constitution. In this case, the U.S. Constitution. It does not necessarily mean illegal, though it often raises constitutional problems, but it does mean that the power or doctrine is not explicitly provided for in the Constitution, cannot be directly traced to an enumerated power clause or original intent, and often rests on judicial interpretation, executive practice, or legislative policy rather than constitutional authority. Examples of extra constitutional doctrines. Number one, federal plenary power over Indian affairs, not found in the Constitution, created by courts, operates without tribal consent, and overrides local government, making it extra constitutional. Two, political parties, now central to American governance, but they are not mentioned anywhere in the Constitution. Executive orders and agencies. Congress delegates broad power to executive agencies to write regulations. This administrative state has grown beyond the original constitutional framework, and scholars debate whether it is extra constitutional or unconstitutional. Distinction: extra constitutional versus unconstitutional. Term and meaning: extra, outside or beyond the Constitution, not directly authorized, but constitutional, possibly tolerated. Unconstitutional, violates the Constitution, contrary to its text, structure, or principles. An extra constitutional act can become unconstitutional if it violates individual rights, infringes on state sovereignty, or contradicts express constitutional provisions. Application to tribal land control. When federal control over tribal land is called extra constitutional, it means the Constitution does not authorize this specific power. Nowhere does it say the U.S. holds tribal land in trust. The power arose through judicial invention and congressional assumption, not through constitutional amendment or tribal consent. Therefore, it exists outside the Constitution's enumerated powers and may conflict with foundational principles like sovereignty, property rights, and federalism. In summary, extra constitutional means outside the Constitution. Actions or doctrines with no express basis in constitutional text or structure, though they may be practiced or enforced. It is a warning term used in legal and constitutional analysis to highlight unjustified expansions of federal power or governance without lawful foundation. He who fails to assert his rights has none. What is the maxim of law? He who fails to assert his rights has none mean. The legal maxim, he who fails to assert his rights has none, expresses a foundational doctrine in both constitutional and common law traditions. Rights must be claimed, exercised, and defended, or they may be lost or deemed waived. Meaning of the maxim: he who fails to assert his rights has none means a person who does not act to claim, enforce, or defend their rights when they are threatened, infringed, or disregarded may be legally treated as if those rights do not exist because they have been abandoned, waived, or forfeited by silence or inaction. This maxim does not deny the existence of the right itself, but recognizes that in legal forums, assertion is essential to protection, and silence is often treated as consent. Doctrines that reflect this maxim: waiver and estoppel. If a person knowingly fails to assert a right to contest ownership, object to a court ruling, or enforce a contract, courts may rule that the person waived the right. Estoppel prevents a person from asserting a right in their prior silence, if their prior silence or conduct misled others. Latches, delay in equity. If a person waits too long to assert a right and the delay prejudices the other party, a court may refuse relief, even if the right is valid. Abandonment. A right, especially a property or procedural right, can be deemed abandoned if it is not exercised or claimed within a reasonable time or statutory period. Statute of limitations. Rights to file legal claims expire if not timely asserted. The court will not hear the case even if the claim is meritorious. Constitutional relevance. This maxim affirms a citizen's duty to exercise their rights under the Constitution. Free speech. If the people do not speak, the state assumes no opposition. Property rights. If owners do not contest seizures, taxes, or encroachments, their property may be lost. Due process. Procedural rights must be invoked, not presumed. Right to petition. Government cannot be held accountable unless the people actively demand redress. James Madison, 1789. The people must arm themselves with knowledge and assert their rights with firmness. Application in tribal and local governance. If tribal nations or local assemblies do not actively assert their rights to land, self-government, or cultural autonomy, Congress, states, or federal agencies may assume they have no legal standing. The right to self-governance, like any constitutional liberty, must be affirmed and exercised or risk being dismissed, limited, or denied. Summary: rights are not self-executing. The maximum: he who fails to assert his rights has none. Warns that failing to speak, act, or challenge unlawful interference will result in the practical and often legal loss of those rights. It is a call to assert ownership, file petitions, challenge encroachments, and exercise liberty with vigilance. All of this reminds us of the beginning of trust video where we said, under Roman law, it was not possible to give property by will to certain persons, for instance, persons not Roman citizens. Roman law restricted inheritance by will. Some people, some people, e.g., foreigners, could not receive bequests. It became customary among the Romans to devise property to one capable of taking it with the request that he deliver it to a devisee who was incompetent to take directly. By our silence, we are often deemed incompetent and sometimes wards of the state. We say all that to say this: we believe that through the power of, first and foremost, Almighty God, and our gaining the knowledge necessary to protect and preserve our God-given rights, along with structuring our estates into private trust, we are able to pass on generational wealth to our future generations as their right to the pursuit of happiness, which in turn ultimately leads to freedom, justice, and equality. What does structuring our estates into private trust mean? Structuring our estates into private trust means transferring ownership or control of property and assets into one or more private trust agreements so that those assets are managed, protected, and distributed according to specific terms set by the creator of the trust, called the grantor or settlor, without relying on government-managed probate, corporate structures, or statutory entities. This action is lawful, constitutional, and historically grounded in common law, natural rights, and the unalienable right to contract and own property. When done correctly, it is a powerful expression of self-governance, family sovereignty, and intergenerational wealth protection. What is a private trust? A private trust is a contractual legal arrangement where the grantor settlor conveys property into the trust, a trustee manages that property, and one or more beneficiaries receive the benefits, income, use, inheritance, etc. This structure does not require state registration and does not depend on corporate law like LLCs or corporations. It arises from the natural right to contract under the U.S. Constitution, Article 1, Section 10, and common law of trust, and the equitable principle of asset stewardship across generations. Purpose of structuring estates into private trust: avoiding probate. Assets held in trust do not go through court-supervised probate. This keeps matters private, efficient, and under family control. Preserving generational wealth. Trusts allow precise instructions for how assets pass to heirs, protecting against squandering, seizure, and disinheritance. They prevent fragmentation of family land or business assets. Maintaining privacy and autonomy. Trusts are private contracts, not public filings. There is no need to report to state secretaries unless engaging in regulated business or publicly traded investment. Asset protection. Properly constructed trusts can shield property from creditors, lawsuits, and predatory claims. The trustee, not the individual, holds legal title. This separation offers protection if properly maintained. Expressing self-governance. Creating a private trust is an act of lawful self-governance under the principle of domestic control over property and family affairs. It reduces reliance on state-controlled mechanisms or statutory business forms. Types of private trust in estate structuring. Revocable living trust allows lifetime control but becomes irrevocable upon death, avoids probate. Irrevocable trust permanently removes property from personal ownership, stronger asset protection. Spendthrift trust restricts beneficiary access to protect from creditors or poor management. Dynasty trust holds property for multiple generations without estate tax in each transfer. Private family trust used for land, family business, or private assets passed intergenerationally. Legal foundations, U.S. Constitution, Article 1, Section 10. No state shall pass any law impairing the obligation of contract. Unalienable rights doctrine, the right to own and control property and to contract for its management and inheritance is natural and pre-political. Trust law is upheld across all 50 states under common law and is not dependent on a license, registration, or statutory approval unless the trust engages in activities requiring regulation like banking, securities, or certain public offerings. Summary: structuring your estate into a private trust means transferring ownership of your property to a private legal arrangement so that it is managed and passed down according to your terms, outside of probate, free from unnecessary public intrusion, and in a way that honors your natural right to govern your family's wealth. It is a powerful tool for intergenerational sovereignty, property protection, and lawful independence from state-controlled estate systems. Fulfilling the prophecy in the Bible in Proverbs 13:22, which states, "A good man leaves an inheritance for their children's children, but a sinner's wealth is stored up for the righteous." To learn more about how you can provide for your children's children long after your passing away by means of a private trust, email us at info@naturalessencellc.com or call 708-539-9201. Thank you once again for tuning in to Know Your Rights University in association with Natural Essence LLC. Until next time, peace and blessings to you all. Thank you.